All right, good afternoon, everyone. I'd like to welcome all of you to our CLE today, the St. Louis City Circuit Court update for 2021. My name is Jennifer Matthew. I am the CLE Director for Alaris. This CLE has been approved for 1.2 hours in Missouri. I just have a couple of housekeeping items and then we will get to the reason that we're here today. Next month, we have another CLE that we're presenting. Maya Markovich is speaking. She is the Chief Growth Officer for Next Law Labs at Denton's. She's speaking about incorporating the entrepreneurial mindset into the legal space. So some really forward-thinking stuff from her. And that'll be, February 11th from 12 to 1, and the registration is open on our website. So that is alarisadr.us. So after the webinar has concluded today, you will receive a survey. We are always looking for ways to improve, and we will share the comments with the presenters. So be aware of that since they are all judges. You will receive a certificate of attendance, usually within 48 hours of the webinar. And if any of you are joining us by phone only, please send an email to marketing@alaris.us. That way we can ensure that you receive your certificate of attendance. So if any of you have questions today, please submit them through the Q&A link. I know the judges will try to answer as many as they can. So it is my absolute pleasure to introduce our speakers today. I will start with Judge Rex Burlison. He is a graduate of SLU Law. He was appointed to the bench in 2000, and he was the presiding judge for the past 2 years, and he is now in Division 10. That's right? Okay.
Yes.
Making sure. And then I'm moving on to Judge Nicole Colbert-Botchway. She is also a graduate of SLU Law, appointed to the bench in 2015, and presently she presides over Divisions 24 and 29. And then lastly, we have Judge Michael Stelzer, third graduate from SLU Law, and he was appointed to the bench in 2004. He is the current presiding judge, which I believe started about 12 days ago. So without further ado, I wanted to start off, and please, again, ask questions through the Q&A link throughout. I did not get very many questions in advance of our CLE today, but we do have a lot to cover. So my first question for you, Judge Stelzer, if we can start with you, regarding the court phases, and we were just talking about Order 28. So if you wouldn't mind going and just talking about that to the group and kind of where the court is right at this moment.
Okay, so we are in phase 1, and I would emphasize that, you know, our Order 28 was crafted very well and very carefully by Judge Burlison, and it relies less on the phase that you're in. And we've been in phase 1 for a while because of the Supreme Court directive that talks about when you have positive tests in your building. We've stayed in phase 1 and we're very comfortable with Order 28. It allows us to stay in phase 1. It does have a lot of information in there. I'm going to try to go over some highlights, and Judge Burlison probably has a better handle on it than I do, but I'll give it my best shot. So you can still have in-person hearings. It would just have to be, the judge would have to find that there's no other alternative but to do it in person. And I think we do have a lot of information in there about what kind of safety procedures are in place if you're coming into the building, including masks, temperature screenings, things like that. So we have, again, we're very comfortable with staying in phase 1. We obviously are trying to follow the Supreme Court order, which came out in July and is in effect as of August. And that deals with, you know, trying to work remotely as much as possible, which we're doing. But we've also put other systems in place, like we have really restricted the movement of the pretrial detainees. So all of that has to go through the presiding judge if you're trying to bring folks in from the Justice Center or the workhouse. And that's, I'm not saying it's been perfect, but I don't think we've had a lot of issues with COVID in our facilities versus other places across the state. You know, right now, we have not really, we have a grand jury operating, and we've had a grand jury operating for a while now, and we're taking a lot of precautions with them as far as how they hear witnesses and things like that. And so as far as the phase goes, I'll just repeat that we are in phase 1. But I think the focus is being more familiar with COVID Order 28, which is on our website.
And then for the listeners, if they're not familiar, Judge, that website is stlcitycircuitcourt.com.
Correct.
Okay. And Judge Burlison, did you have anything you wanted to add to that?
No, I think Judge Stelzer hit it on the head. The important thing is to limit who comes in and who comes into the courthouse, and those that are allowed to come in for in-person hearings to know who they are, and that's required by the judge's order allowing them in, and which is transmitted to the sheriff's desk at the security. So we know in case of contact tracing needs, we know who's been in the building and at what times. But Judge Stelzer hit it right on the head.
Okay. And then Judge Colbert Botchway, if you wanted to comment from the associate circuit perspective, I don't know how many people you've had in person, but if you could talk about that and sort of how is that a division by division decision and how people are getting into the courts if needed.
Thank you. We do follow the Rule 28 as well in the associate bulk divisions. Last year, I presided over Division 28, which is bulk landlord, tenant, small claims, and friendly suits. I did have a couple of in-person hearings when I found that virtual hearing was not adequate, particularly one friendly suit that I had where the individuals needed a determination of what percentage of the settlement each sibling would have. There was a need to have those individuals in the courtroom and a special request for a special setting in advance. So I prepared an order, listed all the individuals who were required for that hearing, who were to appear in court, included their telephone numbers. We had social distancing in the courtroom, and everyone had masks on. Everyone is temperature tested when they come in, and they would have indicated that they have not been around anyone in the past week or 14 days with COVID, and that they did not have COVID or fever or anything like that. The hearing went well. Unfortunately, 2 or 3 days after the hearing, I received a phone call from the attorney that had requested the hearing, indicating that their client's witness had tested positive for COVID. So myself, my clerk, both got tested for COVID. And then we all quarantined until our results came back. And then we had to contact everyone else that was involved in that hearing. Some of the people were outstate. And so it was a very challenging situation, but we got through it. I actually got a thank you card this morning when I was in the office from one of the siblings who was very pleased that we took the hearing in person, that they were able to come in and participate, and that they were giving a percentage of the award, even though that was not the request of the plaintiff at the time. And, all's well that ends well, but it was kind of a dramatic situation. I believe that our court, we do everything that we can within reason, within the confines of safety concerns to move forward. We've been open the whole time during COVID, and I just would applaud the leadership of our past presiding judge, Burlison, and our current presiding judge, Stelzer, because leading through a crisis is very difficult, but we do all that we can.
Absolutely. I do have a question, just generally procedurally, if attorneys, this is for anyone, wish to have a hearing in person, do they petition each individual division, or how does that work?
Yeah, I mean, if your case is in front of a particular judge, then you would need to discuss that with that judge. They would need to make a decision on whether they believe it's appropriate to have whatever the hearing is, or whatever the bench trial, whatever it is, as an in-person proceeding. And then I think you need to notify the presiding judge of what you're doing, get the appropriate orders entered so that we know who's coming in the building, where they're going, what time they're going to be there, all of those things. So that you would need to contact the judge that has your case.
Understood. And then I know, Judge, you were doing, and I know Judge Burlison was as well, the informals are, I think it's Mondays and Wednesdays
Correct.
at 9. And it sounds like most of the court proceedings are via WebEx or remote. Do you want to talk about that a little bit?
Yeah,
And how
so
that's been working?
I'm doing the WebExes for informals in Division 1 on the civil docket at 9 a.m. on Monday and Wednesday. We always have a few people log on. A lot of it is consent orders that they just need entered, or they're looking for trial dates, which we're pushing out, quite frankly. That's just the reality of it. So yeah, there's a lot going on WebEx. I mean, we're doing status conferences, guilty pleas, probation matters. I think the family court judges have been doing a lot of status conferences, but they've also had a number of bench trials on WebEx. The associate circuit judges, as Judge Botchway pointed out, they have been handling bulk dockets on WebEx. It's my understanding, correct, Nicole?
Yes.
Okay. So orders of protection, things like that. So there is a lot going on. Preliminary hearings are being held. Occasionally, some of these items are done in person, but the majority of them are being conducted on the WebEx platform. And I think that's probably, that's going to go on for a little bit longer, I'm sure. So.
And have you found, and I think maybe I'm being a little bit in jest, but that maybe more people are showing up for their court dates now that it's online?
Yeah, I mean, I think that obviously it's a little easier from a time standpoint, especially for something as simple as a status conference, to just log on and then you're there. You don't have to leave your office. I mean, I could certainly see continuing to do some things on WebEx even after, the pandemic has passed. However, I will also say that I am looking forward, to being able to get back into operating the courthouse in a more normal fashion to what we're all accustomed to, because the reality is that the courthouse, the courtrooms have a specific significance, and there are just certain things that really should be happening in a courtroom. So I think I'm speaking for myself that I look forward to when we can get back to doing more of that in the courtroom, but I don't want to, I don't want to dismiss some of the things that we've learned from using WebEx, which is that it can be a very efficient tool, not so much really for the judges, but I think more for the lawyers, quite frankly. I mean, I'm going to be in my courtroom on the WebEx tomorrow morning handling some things, so it's not any different for me, but for the lawyers who don't have to make a trip down here for something as simple as a status conference, it can be a time saver. So.
Understood. Yeah. Well, for example, we'll have a mediation that starts at 9:30 and they can do their simple informal at 9 and jump right into mediation.
Right. They don't have to be two places at once.
Right. So we do have a question on here. For civil informals, is there just a general meeting that anyone can join, or do we need to sign up?
No, at this point, you just log on. My WebEx, I believe, is on the front page of our website. I'm pretty sure the last time I looked, it was there. And so you just click on that and that brings you into my WebEx. I log on at 9, and whoever's there, if we have a match, all the lawyers are there, then I'll handle whatever they have going on and then just move on to the next one. So.
Okay. So you talked a little bit about the precautions. I just had a couple questions on that. So the kiosks, when people enter, these are more logistical questions, but how does that work when someone enters the courthouse?
Okay, so if you're coming into the courthouse, there's a lot of things going on. It really sort of depends on why you're coming in. Like you can get to the cashier if you need to, but I think we have and Judge Burlison, please jump in if I say something that's inaccurate here, because you're much more knowledgeable of this than I am. I think they get an escort to the cashier. There's precautions in place, temperature checks, all that's going on. So you can get past the deputies. If you have an order from a judge that says you need to be in that judge's courtroom at a specific time, then you will be allowed in. But again, you have to agree to social distancing, limited number of people on the elevator at a given time, all of these things that we've put in place. If you're there to file certain things, like especially for pro se litigants, we do have computers set up and they can call up to the clerks who will come down and help them, so that we're sort of limiting who's coming into the courtrooms there. So a lot of it just depends on why you're there and whether there's an order in place that says, yeah, you can come in and go to this division at a specific time.
Okay. So we knew we were going to talk a lot about civil dockets and civil trials. I've got a couple questions here, but I wanted to give you the floor, whichever of you would like to start.
regarding if you get to phase, I think it's 3, where you can start having actual jury trials, if you want to address that, and then we can talk about some of the other questions we've received.
Okay, and again, Judge Burlison, whenever you want to jump in.
Well, at this point, I think just before we get to the next question,
Right,
so we have between the front doors and the security desk, we have the computers that are available to the general public, so they can come in without getting actually into the building and having a court order allowing them past the security desk. But we also have a different aspect, probably Judge Colbert Botchway it will be able to explain, but we do have a room set up that's inside of the Carnahan Courthouse that you would, the user would have to get by security. But that is an actual room where you can go in and be hooked up to have a hearing for those who do not have computer access or internet access at home. They can be allowed to join a hearing through that room. And Nicole, if you could just, because I know your division uses this quite a bit, but just get an example of how someone would be able to participate in a trial by using that room.
Oh, thank you. So we had a, I believe it was a small claims hearing where the defendant needed an interpreter. So this was after we had the situation with a positive COVID inflicted witness in the courtroom. So we were very leery about having everyone in the courtroom again. So we had a special setting in this situation because a WebEx hearing would not have been appropriate when the defendant, the lady, needed an interpreter. So we had a special setting where both the interpreter and the defendant appeared in the courtroom that we've set up for WebEx access in the Carnahan Courthouse behind the old Division 16. So she appeared there with the court reporter, with the interpreter, and the plaintiff appeared by WebEx, and I presided by WebEx in my courtroom. So it was virtual in the sense, but it gave the individuals who did not have access or have that different special circumstance the opportunity to still fully participate in the trial. Another situation that has come up is that individuals may appear by WebEx, but we don't have the documents. They're not attorneys, so they are not scanned into CaseNet in advance where we could just click on the document and share the screen, which is what I usually do. If their attorneys or individuals file their exhibits in advance, then I will just open the exhibit on my screen and share it. And everyone that's participating in the hearing by WebEx can see that exhibit, can make objections to that exhibit. But in a situation where the individual has not sent those documents in advance, they're not scanned in, they're used to just walking up to the courthouse with their documents in their pocket or whatever and handing them over, especially in a small claim setting. This is a different scenario. So we do have a basket set up on the first floor of the civil courts building with the division number on that, particularly for 28 and 27, where individuals can drop off their exhibits in advance. The clerks will take them and scan them. With the courtroom with WebEx, there's generally a sheriff in that division with the individuals, and then the clerk is also available to run over, pick up documents if need be, and bring them back to me in the courtroom to review them. So that opportunity has really given us the chance to provide more trials than we could before. We do have many more continuances, even when the parties say they're ready for their hearing. If we don't have the exhibits we generally grant a continuance so we can get those filed in advance, because otherwise there's no way to review all of that evidence.
Why I wanted to add one comment on the Monday, Wednesday docket that I have at 9 a.m. There are some lawyers that log on just because they know their case is coming up and they would have traditionally come up to court and asked for a continuance. That docket is rolling automatically. It's fine if you still want to log on and discuss it with me. I'm not discouraging people from doing that. But if you're just on the rolling docket, that docket's going to just continue to roll every 6 weeks unless you tell me some reason not to. For example, if it's settled or something like that, or it's been dismissed for some other reason. So just keep that in mind. It's not necessary that you log on to those informals on Monday and Wednesday. For the time being, that docket is just being rolled out every 6 weeks. But back to the question on jury trials and when are we going to get to that? I'll tell you my best thought on it, but I'm hesitant to go down that road too far because I just think it's just still an unknown right now. For example, yesterday after I sat down with our jury supervisor and our court administrator who are tracking all kinds of information on this topic, from what's going on out in the community with COVID cases and hospitalizations and following the St. Louis task force on this to contacting other, especially larger urban courts around Missouri and in the St. Louis area, we made the decision that the only safe thing we could do at this point was to cancel. We had already canceled January 19th, so I went ahead and canceled the jurors for January 25th and February 1st. There were a small number of criminal jury trials that had been set some time ago, earlier in 2020, that were set on those 2 dates. And we had discussed this with the judges who had those cases set. So they were aware that I was doing this. And the vast majority of those cases, as it turned out, probably were not going to make it to trial those weeks anyway. So, what I'm trying to do is work a couple weeks ahead. We have this priority list of criminal cases is mainly what we're focused on, but we know that there are civil cases set as well. And I'm just trying to monitor what I think is a safe decision for bringing jurors into our building. And, agree or disagree, I made the call yesterday to cancel through the week of February 1st. So we will continue to do that, though. We will continue to look at the situation in the community, what other courthouses are doing, and what we feel is a safe way to handle this. And hopefully sometime sooner rather than later, we will be bringing jurors in. But for me to give a pinpoint on that, I think it's too much speculation at this point.
So we have multiple questions. That one of them that you think you just answered it, but the question is, will the civil cases remain on the rolling docket this year or be assigned out to a trial judge for trial?
Well, I think once we get to the point where we're comfortable bringing jurors into the building, then I think, we will at some point start sending civil cases out. I will say there's one school of thought that, a short case might be the best way to end our jury trial drought. So, keep that in mind. And I've even talked to Judge Botchway about that because she's in the division where that kind of jury trial may exist. So we are looking at a lot of different factors. We understand that there is a lot going on here. We have a criminal docket that is getting older. We have a civil docket that is getting older. We are very aware of that. It's not that we're unaware of it, but we have to make our decisions based on what the science is telling us. And right now with COVID sort of on a rampage, it just doesn't seem like the right time to try to delve into this. So,
well, and I think a lot of our attendees and listeners are looking for a little bit of predictability in this unpredictable time,
Sure,
which you,
sure.
I know, understand.
Very understandable.
One of the questions, it says, it sounds like the judges won't be predicting when civil trials will be resuming, which you just mentioned, but have they reached a consensus as to how far out and a minimum it will be? In other words, don't expect a trial until December or something like that.
I think a lot of that depends on what's going on with vaccinations and things like that. I mean, if we had a better rollout on the vaccinations, and maybe you could see something happening a little sooner rather than later. But I mean, do I think we'll be bringing jurors into the building before the end of the year? Yes. Do I think we'll be bringing them in the fall? Probably. And I guess I'll probably end it there because I just don't know. I would love it if this would get better out in the community and the vaccinations would get going. and all that. And I could say, sure, in April or May, we're going to be up and running. But I just think that's it's a hard question to answer right now. So that's why I say I'm looking at it a couple weeks out is sort of my time frame at this point. So
You mentioned vaccinations. I'm just curious, do you have any idea when the courthouse staff or the judges or anyone will be receiving those if possible?
we talked with some folks at the state level. They referred us to the local health people. So that's the angle that we're pursuing right now. But again, depends on what group you're in. And we are definitely not in 1A. I think we may be in 1B, but they haven't even finished vaccinations for 1A. So, so that could be a little bit down the road, but we're definitely looking into that. But again, no real clear-cut answers yet.
Okay, this question's for you, Judge Stelzer. This person
You
said,
sure you don't want to ask one of the other judges?
it literally is directed at you. So
Okay, fair enough.
it says, I know Judge Burlison was amenable to entering agreed to case management orders on civil cases if it was agreed to by all counsel and emailed to him and all opposing counsel. So Judge Stelzer, would you be agreeable to this procedure as well, or do we need to set a web hearing?
Not only am I agreeable, I have already done that on several cases. Now, I will say those were cases where folks had logged on to the WebEx probably because they weren't sure what the answer was. So the answer is yes. If there's a complete consent to it, email it to me, email it to everybody, and that's fine. Let me know what it is, and I'm happy to print it out and sign it. So,
Okay.
Not a problem. Although I will say, on the scheduling order, I'm assuming that they need a trial date. So I guess that's probably something that they may want to contact me or Patrick about is a trial setting. But other than that, yes, you can email it to me and I will sign.
Great. And this is for any of you. Someone is asking, is the court accepting affidavits to accompany default judgments or requiring testimony?
Well, I can jump in. I in the last few months, normally defaults should go through the motion doc or divisions, but because a lot of folks when they look up their case and it doesn't have a judge assigned, it automatically has Division 1 assigned. So I was hearing defaults as a convenience. I did not make record. I told the attorneys that the record that you're making is the one that you'll have to uphold in the future. But if you want to submit affidavits and do it on an informal docket, I'll sign the order. But rest assured that the record is going to be yours to defend. So I don't know how Judge Stelzer, but I was doing that more out of convenience, but normally defaults should properly go through the motion divisions.
So I have actually got an email on that right before I came over here from on a case from the lawyers. So I didn't have time to really look into it or think about what I would do. So the answer is I don't know. I may continue what Judge Burlison's doing, or I may contact the motion divisions and have those. I don't know what I'm going to do yet. I haven't been faced with that, but I'll be working on it today when I get back to my office. So.
And then I do have a couple questions. They were submitted before today. I just want to make sure I didn't forget to ask them. So this is about gaining access to the courthouse for a trial tech. So each building has their own security measures to access the courthouse. And in order for a trial tech to bring the carts of audio and video equipment and to set up for a trial, they have to request the attorney to fill out a court order and submit it to the judge presiding over the case for approval, which we've talked about. The trial tech would then get a copy of this signed order and present it to security in order to gain access to the courthouse with their equipment. Will this be the same protocol moving forward?
I don't know why that would change, but I would also think that if it's something going on during the pandemic, when our COVID order 28 is still in place, that order should be done ahead of time. It should already be with the security desk, but certainly it's helpful if the tech has a copy of it and can present it. But again, if it's happening under our current circumstances, that lawyer should have already presented something to the judge about this. It should have been signed and already, been handled at the security desk. So I think I'm answering that question. Yes.
Okay. And the next question similar is, would the courts consider an alternative where a trial tech could apply for a background check or something to gain credentials to the courthouse similar to, attorneys showing their bar cards to get through security quicker. And I think this person is mentioning how it can be cumbersome, it can take a long time, there's long lines, et cetera.
Okay, I had not really considered that, but again, right now, there's not going to be a long line. So if you're talking about something that's going on during COVID, it should be handled the way we've been doing it, which is get the order ahead of time to the sheriffs. For future, when we're out of this, I don't know the answer to that. I see where they're having a concern, but I as I'm sitting here, I don't know if we would change how we're doing that or not.
Jennifer, there's a history on why you need an order that allowing equipment in the courthouse. This was in effect for years before COVID. And it goes down to essentially two issues. One is bringing equipment into the courthouse of any nature needs to be searched and be inspected at the security desk. We had this occasion years ago, not in this jurisdiction, but where someone left a handgun in a gym bag of their equipment that poses a security problem. And the other is we have a rule about cameras in the courthouse. And so in fairness to the security guards, their default is cameras are not allowed in the courthouse. So in order to get by their default position, you need to have a judge's signatures allowing equipment, specific equipment by specific people to be allowed in the courthouse. So and both of those things are pre-COVID, both of those issues.
Okay. Thank you, Judge. Another question on here. After the court returns to normal operations, will remote informals and more preliminary matters continue remotely? He says, not that we don't love hanging with the judges, but it is certainly easier and time saving.
I'll try to answer that. I can see where we may want to continue to use WebEx, and we were already doing things like phone conferences where people could call in and things like that. So it's not a complete unknown, to our courthouse. I can certainly see where doing some statuses that are pretty simple issues by WebEx would work. But I will also say that there's nothing like having the parties in front of you to make some progress, even if the case doesn't get resolved. And on criminal cases, that can mean having the defendant there. On civil cases, it can mean having both lawyers in the courtroom where they can have a discussion. I did motion equity for 2 years in 2018 and 2019. And I'll tell you what, some days you can walk out and see a courtroom full of lawyers and think, oh my gosh, but on the other hand, they're in there talking and discussing their cases and they're getting issues resolved. So I think there is some benefit, again, to physically being in the courtroom, but I can only speak for myself. I will definitely be looking at opportunities to continue to use WebEx where I think it's appropriate and especially where it will be convenient for the parties. But I don't want to lose that opportunity to have everybody in the same room and maybe get the issue resolved short of the court having to issue an order on everything. So.
In the associate divisions, I've heard from the attorneys, particularly the consumer attorneys and landlord-tenant attorneys, that they are anxious to get back to in-person because generally at a first setting, they have an opportunity to speak to the defendants and usually work out some type of agreement or payback plan. Even though we do have rooms in WebEx, it's more cumbersome than the Zoom breakout rooms. And so it's difficult for them to work out agreements now, is what I'm being told. So I think as far as the bulk hearings, when we have 80 to 100 people showing up on WebEx, we're pairing people up, we're sharing contact information, and then they're following up with them offline. Previously, they did that in person with a lot of success. The defaults are the same situation. Usually we make sure that the individuals actually received the summons with the WebEx information. So there may be a continuance the first time around in case there was some miscommunication. But on the second setting, there's usually a default is taken. So that's not really an issue, but it's when individuals appear and the attorneys are missing out on that in-person contact to work out an agreement is what's being lost with the virtual is what feedback that I've received from the attorneys.
Thank you. Another inquiry. Has the court developed a standard case management order form to be used this year?
Oh, you mean like something that would sort of take into account the COVID issues?
I think that's what they're asking.
I'm not aware of that, and Judge Burlison may be able to speak to that. The only thing I can say is what I spoke about earlier, which is that the civil docket is rolling automatically unless there's a reason not to roll it, again, like a settlement or a dismissal for some other reason. So I don't think so, but I might be missing something. I've only been up in Division 1 since January 1st, so I'm not completely familiar with everything that's going on up there.
As far as case management or scheduling orders, those are required by local rule to go through Division 1. In my 2 years, I only had one rule on scheduling orders, and that is they will be by consent. So if there was arguments about a scheduling order, I typically told the attorneys that's probably something that needs to go first to the motion judge if it's contested. And that seemed to pave the way for a consent order. But that was my only rule, is that the parties all agree and not expect the court to get involved to see whether or not 30 days is better than 45 days or whatever.
Thank you. So another topic I'd like to cover is priority. I know that we've talked about this offline a little bit. So we have a question from one of the attendees. So the question is, when does the city anticipate having civil trials? We've answered that. And does it depend on the length of the trial and the complexity of the case? So if a case is set peremptorily in April and a second one in July, will those be conducted? And if it is now know that these cases won't be jury tried, is it recommended to obtain a new setting now via the informal Division 1 docket for cases not yet assigned to an individual judge?
Okay, that's kind of a long one. I'll give it a stab. So when will we start civil trials, and is it dependent on the length of the trial? I think there is something to that. I think it will be easier for us just because of the number of jurors necessary for a shorter trial, especially in a civil case, to think that that could be, something that we would be looking to send out sooner than a 3-week trial, where we're going to have a large number of jurors that we're going to have to try to pick from. So I do think there's something to the argument that a shorter trial with fewer witnesses and parties, which means fewer people in the courtroom, is something that could go out first. Does that mean it's a priority? I'm not really sure what they mean by that. I mean, we're still trying to look at our peremptorily set cases for sure. And on the criminal side, we're definitely looking at what we consider priority trials as communicated to Division 1 by the trial judge and the prosecutor and defense lawyer. So there is something about priority trials that we are looking at, but we also have to be realistic about, the comfortability level of jurors to be in a room with a small number of people versus a large number of people. And at the end of the day, we can talk about all this that we want, but if the jurors aren't comfortable coming down, then we can't have jury trials. And I think that's the factor that I'm always thinking about is, and I'll run this by my friends and neighbors and relatives occasionally. Hey, are you comfortable sitting in a room full of strangers right now, listening to questions from lawyers? And for most of them, the answer is no right now. And so I just think, we can talk about priority trials. Is a 3-week trial going to go in April? That would be a stretch right now based on what we see going on in the community with COVID. So.
So another question along those lines: if a civil case is set peremptorily in the spring of 2021, should the parties approach the court for a continuance, and would the court be amenable to resetting the case in the first quarter of 2022?
I just was looking at dates in 2022 early on, and there's lots of open dates. I don't know what they mean by the spring yet. I wouldn't necessarily think you'd have to come and see me yet, but some of that could depend on what kind of a case it is also. Again, is it a 2-week, 3-week med mal case with lots of defendants? Is it a 2-car accident case with 2 lawyers and a plaintiff and a defendant? Those are different animals right now. So.
Okay. And I think you said this earlier, but I just want to clarify. So if a case right now you're making decisions about 3 weeks out, I think is what you
Yeah,
said.
but I'm trying to look at 2 weeks out is about as far out as I'm trying to go.
So be patient is what you're saying.
Yes, please, please.
So next question, will the court be doing jury trials on the priority criminal trial list before starting civil jury trials?
I think, yes, I think that's probably true. I mean, we have a criminal docket that's gotten a year older with lots of A and B felons who are confined right now, and the speedy trial issue is out there. So yes, we are looking at how can we get some of those cases resolved. And it's not that the civil cases aren't being considered, but I think I have to look at those first and see what's going on with those, and then move down the pecking order at this point. So.
Yeah, and I think a lot of, I think a lot of civil litigators are just worried they're never going to be reached this year.
I don't, if the concern is, are we going to get to you before December? Yeah, we're going to get to you before December unless this really goes bad again. I mean, if what we're doing with vaccinations and things like that works out the way they expect, then I think we'll be able to get to the civil docket before the end of the year. But again, if you're asking me to pinpoint something more than that, it gets very difficult, or something more accurate.
Okay, another question. Given the pandemic, what's the best practice to request a move from track 1 to track 3 for a recently filed complex case? There was not consent of all parties to moving to track 3.
Okay, then you probably need to either get on the WebEx with me, or I may send it, as Judge Burlison pointed out, we may send it to the motion division then for a hearing. So, but you can start with me, that's fine. But if there's a lot going on in Division 1, so I very well may follow Judge Burlison's thought on that. If it's not by consent, then it may go to the motion division.
Okay. Next question is for you also, Judge. Will you be, Judge Stelzer, will you be open to peremptory settings on run-of-the-mill cases or require specific circumstances like out-of-town length, et cetera, when we return to non-COVID dockets?
I don't know the answer to that. I'm sorry. I have not been presented with that. My understanding is you could get a peremptory setting. It just depended on when you wanted it and whether there was room for a case on the docket that you were looking at. I'm not so sure, and Judge Burlison can correct me if I'm wrong. I'm not so sure. It depends on whether or not you have out-of-town witnesses, although that would certainly be a very good reason to get a peremptory setting. I don't know that you're precluded from getting one if you don't have out-of-town witnesses, though. I mean, that certainly wouldn't be my position.
Judge Burlison, do you have any thoughts on that?
Well, the rule talks about complex cases getting into a track 3. It's been my feeling that that's a hard definition to hold a line on. As Judge Stelzer says, is it complex if you have 5 experts? Is it complex if you have out-of-town folks? Is it complex that you're one of the parties is a doctor that has to schedule cases within windows in order to still service their patients? So because that's such a hard line to hold on what's a complex case, I took the position that if it's a 2-day trial or if it's a week trial, or 6-week trial, if you tell me it's complex and the rule requires you to file a case management order and you want a firm court date, I wasn't going to really get into weighing out what complex meant. I gave priority settings for any trial that anybody told me it needed one, and but you also require under the rule, as I say, to file a case management order, and that we're all here to move the cases. And the case management order with a firm court date is the fastest way to move cases. So that's kind of the way I looked at it.
Thank you. So we've talked about it a little bit. I'm going to switch gears a little bit to the criminal docket. We do have some criminal attorneys that have joined us. And if you wanted to, I don't know who wants to start, but just talking about the, I guess priority has come up, and then also the speedy trial cases and sort of how you anticipate those will be handled.
Well, we fortunately have a local rule that discusses prioritization of cases. And there's a number of items that are listed in there that the court has to consider. And it tells you to consider, I think, first and foremost, speedy trials, out-of-town witnesses, things like that. But then within all those categories, you also look at the age of the case. So hopefully what the trial divisions are doing when they're setting cases that are for priority is that they're looking at those things. It really should be older cases that may have some little twist to them, like an out-of-town witness or an expert, and certainly speedy trials, although not all speedy trials are created equal. If you just filed your speedy trial last week, then that's a lot different than if you filed it 6 or 9 months ago. So that's really, we do have a local rule that is pretty good at covering how to differentiate between criminal cases as far as what goes out first. In this case, who gets the jurors is how I would put it. Who's going to get the jurors? Because that's really what we're talking. We can stack all these cases up on a given week, but we're only going to have so many jurors that come in. And so then it becomes, who gets the jurors? And that's what I'll be looking at, is that local rule. And I don't have it off the top of my head, so I apologize for that. But it's in our local rules and it's pretty straightforward.
And so how are the cases, I know it's during COVID, but how are they being handled in each individual docket? Are you sending those out, or how is that working? Or Division 16,
each division has their own docket of criminal cases, so they're handling them however they're handling them. There's a number of different ways. I have 3, I had a docket last year. I had 3 criminal weeks out of a 6-week block. So I just split my criminal docket in thirds. And I would set status conferences to see if anything was going to plead, to see if there were discovery issues that we needed to deal with, and things like that. Other judges set them all at once and handled it that way. So it just depends on the judge. You have to be able to know, or I guess communicate with the judge that has your case as to how they are handling their individual criminal docket. So, and I even had some hearings in person. We did a few guilty pleas in person because that's what the defendant wanted to do, and they were more comfortable doing it that way. So that's what we did. So.
Okay. And do you know if on your website there is quite a bit of information, and each individual division and judge has their own information on there? Do you have any idea? I know I'm asking you this, but do you know if people can go there and look and see how they anticipate to handle it in each division?
Some judges, I think, have information out there, but I can't speak to all of them. So the only thing I can say is if you go to the website and that judge is not giving you any direction as to how they're handling their criminal docket, then don't be shy about contacting the division. So.
Yeah, Jennifer, on the website, and that's a good point for the attorneys. The first thing an attorney wants to do is go to the website or have their paralegal go to the website. We, back in March and April, we were impressed on the need of messaging to the public on courthouse availability, judge availability. So we were really pushing judges to post what their procedures during COVID were going to be. And, in this circuit, we've got 17 or 18 general trial divisions. Those typically on the civil side will be dependent on action from Division 1. On the criminal side will be dependent by the individual judge. But then we have a group of judges that are in the family and juvenile law, and I know that their procedures are all posted. We have 2 judges in the motion division, and I know their procedures are all posted. I believe all of the associate judges have posted the procedures in their individual courtrooms on the individual type cases that they that they use. So that's been our desire since March and April, is to message to the attorneys through the website. So please take advantage, or have your staff take advantage of what's posted under the individual judges tabs on the website.
Great. Next question is, presumably there is or will be a backlog of civil cases because of the pandemic and the priority given to criminal cases. Do you anticipate a change in how civil cases are assigned for trial?
I think once we get back up and running, it would be my thought that we would assign them out based on the promptorily set cases. And usually when I would get a docket from Division I as a civil week, it would have not only the promptorily set cases in there that I was given, but other cases off the docket as well. So I can't think of a reason why I wouldn't do it that way at this point. Again, but keep in mind that it's going to get back to who gets the jurors. And that's where I think my challenge will be as the presiding judge once we're back up and running, is making sure that I'm consistent in following our local rules on how we prioritize which case goes first, which in this case, really, again, it means who gets the jurors. But as far as assigning them out to the divisions, we have a system in place to do that. So I don't have a good reason not to do it that way at this point. So I think you can assume that, yes, it will be sent. They'll be sent out the same way they always have. The question is when.
So speaking of jurors, Judge, that's a hot topic. Obviously, you need jurors in order to have a jury trial and keep the courthouse running.
Yes.
I know that you probably meet with the jury supervisor, and I know that she's not here, but if you wouldn't mind, I'll give you the floor for a minute, and then there are some questions about that on that topic as well, as far as bringing in jurors and what you anticipate that will look like.
So a couple of things I think we're looking at if and when we do this. Well, when we do this, we're looking at bringing them in at staggered times, things like that. Probably can't bring in the same number that we've traditionally brought in. One of the pieces of information that our jury supervisor gave me yesterday was that our response rate is significantly down. We're still sending summonses out. We're just not bringing them in. And I don't remember what the response rate was before all this, but it's down under 20% right now, which means you have to send out a lot more summonses to get the same number of jurors. So, there are going to be some issues that the jurors will decide for us. The citizens will decide for us. Again, how comfortable are they coming down here? Now, the good news is, we've gotten some really good responses on people wanting to do the grand jury, and we've been able, Judge Burlison seated at least 2 grand juries last year, I believe, maybe a third. I can't remember now. And so we've had good response on that, and we've been able to keep the grand jury functioning to a large degree during all this. So that's good news. But our response rates are definitely lower on the petit jurors. So
I think the answer to this next question is probably it will be up to the trial judge. But the question is, once a jury trial starts, what are your thoughts on jurors who just say they don't feel safe or do not want to appear?
I guess I would put the question back to the lawyers. Do you really want that person on your jury? I mean, the reality is some people may use this as another way to get out of jury service. We all make a lot of jokes about that, but it does happen that some people, for whatever reason, are just not comfortable or just don't want to do it. On the other hand, some people, it will be a legitimate concern of theirs that they really don't want to do this right now after what we've just gone through. So I think as a judge, you have to look at those one at a time. But I can see judges definitely letting people go with that kind of statement coming from the juror.
And so I'm just curious, if a juror refuses to appear at all, who would be handling that? Would that be the jury supervisor?
Well, I don't think we have enough sheriff to go out and get everybody that may say they're not going to do this. I know in the past, used to get charged with a misdemeanor. We gave you a number of opportunities, you probably prosecuted someone that was Jennifer when you were in the circuit attorney's office. But I'm not sure if that's still going on. But there's just a reality here with what we're going through and expecting citizens to come down here. How heavy-handed do we really want to be? And I think the answer is we really don't want to be.
Okay. Do either of the other judges have any thoughts on jurors or on that topic?
Well, Jennifer, what the discussion that I had with the jury supervisor since March was we asked that the jury supervisor and her staff be in contact with jurors who, as Judge Stelzer said, we thought it important to keep sending summonses out for jury duty because, you know, this situation has been up and down, and as far as we've gotten, or the trends have gotten better and worse. So we kept sending out the jury summonses, and then we had the staff contact the jurors and talk to them. And we kind of took the position that if a juror at any point, whether it's upon receiving a summons or and they contact us or we contact them on a follow-up, if at any point they said that they were uncomfortable, I had asked the jury supervisor to reschedule them in a year down the road. We also had a process set up that if when we have jurors parking in the parking garage and then we had a shuttle process to get them to the courthouse, if at any point during that process they told the sheriff deputy that they were uncomfortable, that deputy was to take their badge and report that to the jury supervisor. And I told the jury supervisor that I would excuse anyone I would support any decision that was made to excuse those jurors. Now, how we go forward is obviously Judge Stelzer's call, but that's as he mentioned, we don't want to. It doesn't help anybody to force jurors down here. Only bad things can come out of that. But there are jurors who are willing to step up and be seated. We saw that in impaneling the grand jurors.
Wonderful. Thank you. Well, we are basically out of time and we've managed to answer all the questions that have been posed. So thank you
Great.
very much.
Thank you.
On behalf of Alaris and everyone that's attended, thank you all for your time and your knowledge. And there's a lot going on. We understand there's a lot of things you aren't able to answer, but this was very informative. So thank you again. And just a last reminder for those of you that have joined us by phone, I see there's some of you, please send an email to marketing@alaris.us so we can make sure that we get you your certificate. So thank you all very much again. I really appreciate it. And everyone stay safe. So this will conclude the webinar.
Take care.
Thank you.